Tonight, two big legal setbacks for the former president. A federal judge ordering his White House counsel, Pat Cipollone, and his deputy to give additional testimony to the criminal grand jury investigating the 2020 election. Also, a federal appeals court flat out rejecting the need for a special master to review documents seized from Mar-a-Lago. The 11th Circuit appeal panel stating plainly former presidents should not receive special treatment. I'm quoting from the opinion. In considering these arguments, we are faced with a choice: apply our usual test, drastically expand the availability of equitable jurisdiction for every subject of a search warrant, or carve out an unprecedented exception in our law for former presidents. We choose the first option. In other words, former president or not, the normal rules apply. CNN's Sarah Murray joins us now with more on this and the Cipollone case. So, Sarah, what does this mean, the court ruling on the Mar-a-Lago documents? What does it mean for the DOJ and their investigation?
Well, I mean, obviously, it's a big win for the Department of Justice, who had been arguing that there shouldn't have been a special master in this case all along. Practically, it could mean that they will get this whole mess of documents sooner than they would have otherwise. Remember, they already have access to the roughly 100 documents that were marked classified, but there were thousands of these other documents that they want to use to try to make their case about how things were stored haphazardly at Mar-a-Lago. So now they could get them sooner. Of course, the X factor is, will Trump appeal? We have seen his willingness to do so in many related cases. You know, he earlier appealed something to do with this case to the Supreme Court, and he may ultimately decide to go to the Supreme Court with this question as well. We should note, though, that this appeals court that ruled against the Trump team today, it is made up of 3 GOP-appointed judges, Anderson.
So if he did want to slow things down, he could try to appeal to the Supreme Court.
He could, yes. If he still wants to try to stall, he could go to the Supreme Court. He could ask for some intervention there. He could go back to this court, frankly, and ask for the entire panel to hear it. So he could ask them to hear it en banc, although I'm not sure why you would do that, given the panel of sort of sympathetic or possibly sympathetic Republican judges he had, and, you know, how they very clearly ruled against him.
We mentioned Pat Cipollone's been ordered to give additional testimony before the grand jury investigating the efforts to interfere with the election. He already appeared back in September. It was obviously before the special counsel Jack Smith was appointed to oversee the DOJ criminal probe. What happens now?
Well, that's right. You know, what we have learned is that a judge ruled that Cipollone, as well as his deputy, Pat Philbin, had to go back to the grand jury and testify. Now, again, this is all happening behind closed doors. This is a secret court proceeding. And Trump's team had argued that because of privilege issues, that they shouldn't be able to answer certain questions for the grand jury. Now the question is, are these guys going to get swept into the grand jury quickly? Are they going to go there and answer questions? Or will Trump's team first appeal before they go back there? We do expect an appeal by the Trump team, so we're going to wait and see how this plays out. Again, this is all playing out behind closed doors, so we're learning this from people who have been briefed on the matter.
And just to be clear, this is the criminal grand jury probe for the Justice Department.
That's right. This is a criminal grand jury probe having to do with efforts to overturn the 2020 election. And remember, these guys were in the White House. They were around the former president. They were there when he was, raising schemes about trying to go to states, when he was, suggesting this potential coup at the Justice Department. So they have obviously seen a lot.
Sarah Murray, appreciate it. I want to get some perspective now. Our two CNN legal analysts, Carrie Cordero and Ellie Honig, also CNN political commentator David Urban, former Trump campaign advisor. Carrie, how helpful, in your view, is this ruling to the Justice Department's investigation going forward?
I think the 11th Circuit ruling is important in the case. What it did is it basically said that the former president is not entitled to special treatment, that executing search warrants is a standard process for the Justice Department, for the FBI, when they're conducting an investigation, that when that warrant is based on probable cause and it's approved by a judge, that there really were no strong arguments made by the former president that a special master should be in place and that he should receive any special treatment. So I think the 11th Circuit case, in the opinion that was just issued, really resets this case in terms of the way things normally would work for any individual who is the subject of a search in any investigation around the country.
Ellie, how do you see the opinion?
Well, Anderson, first of all, this opinion is all about what we call jurisdiction, meaning the courts can't just do anything they feel like. And what the Court of Appeals today said is that the district court, in ordering the special master, went too far. That's not a thing that courts can do. You cannot interfere with a criminal investigation at this stage. And as a practical matter, what this does is it removes a roadblock or a speed bump for the Justice Department. It means that unless this case goes up to the Supreme Court and gets reversed, which I think is very, very unlikely, DOJ can now take all those documents that they seized at Mar-a-Lago and use them fully in their investigation. So it will enable DOJ to carry on with their investigation in a speedy manner.
David, just in terms of the legal strategy, do you think it was a mistake now for the former president's legal team to go through the route of requesting a special master, or if gumming up the works or slowing down the process was the goal, was that successful?
Yeah, so Anderson, I think we've had this discussion before. I think that the president has one idea and his legal team may have a separate idea, and he's the client. And I think they filed this suit, and facially they had a claim, and has been pointed out by the 11th Circuit. There's these three judges on the 11th Circuit. They don't really have the standing to do so for a variety of reasons, separation of powers and others. Look, I anticipate that the president's legal team will appeal and ask it to be heard en banc by the entire 11th Circuit, which likelihood of success there seems pretty slim. And then again, they'll appeal to the Supreme Court. I think that it's a tactic that we've seen before from the president's lawyers in terms of just delay. And I think that they'll continue to delay until the absolute last moment they can, and Supreme Court doesn't take it up. I don't think the Supreme Court will take it up, but they will. They'll take it to the 11th Circuit on bank, and we'll see what they have to say.
And Kerry, how long could it slow things down? I mean, the ruling by the 11th Circuit doesn't go into effect for 7 days, which obviously gives the president time there.
Right, so it gives him time to appeal, and so then there'll be a determination whether or not the Justice Department can go ahead and actually look at the information. So there is, some, I think, a little bit of ambiguity as to whether or not they can start looking at the information right away, or whether or not they're going to have to wait a little while. I don't think there's any credible basis for the en banc appellate court or for the Supreme Court to take up the arguments in this case. And I think it's important to point out just how unusual the former president's arguments were in this case. The normal time that an individual would challenge the results of a search and say that their rights had been violated is when they've actually been charged with something. And so the former president, in his legal strategy, really jumped far forward here by trying to make arguments that his constitutional rights were being abused in some way by the way that the FBI handled this search. That just is not the way that normal investigations would work in any other matter.
Yeah.
Well, and go ahead.
I was going to say it's clearly a setback for the president in any way you look at it.
Yeah, Ellie, I mean, if the former president is in fact eventually charged with a crime, would he have another chance to challenge the search warrant then? I mean, to Kerry's point?
Yes, he would, Anderson. That's precisely the basis for the court's opinion today. They say, essentially, you're not special. They say, look, we have a couple choices here. Either we could say everybody gets a special master after a search. We don't want to do that. We could say nobody gets a special master after a search, which is the normal rule, or only former presidents. They say, we're definitely not doing that. But the way it normally works, Anderson, is if there comes a day where Donald Trump or anybody gets indicted and they want to challenge a search warrant, at that point, the prosecutors will have to give them all the documents, all the paperwork that went to the judge. And you can, and I'm sure if this ever happens, Donald Trump will challenge the search. He'll say it was unconstitutional. He'll say that the prosecutors did not establish probable cause, that the search violated his constitutional rights. And if he wins at that point, then that evidence cannot be used against him. But that's the way this normally works.
Dave, the fact that now the former president says he's running again for another term, I mean, there's been a lot of talk that maybe he thinks by announcing that might slow down some of these investigations or at least complicate them and make them look political. Do you think this ruling in any way affects his run?
Yeah, Anderson, I think it's going to be tough to make that case when you had three Republicans, the judges that issued this, the circuit judges that issued this opinion are a Bush appointee and two Trump appointees. So it's pretty tough to make that case. And then, obviously a lot of conservatives believe that this case was flawed at the beginning because of a separation of powers, argument, right? That the judicial branch shouldn't be interfering in the executive branch's business. So,
Kerry,
pretty tough.
Yeah, Kerry, I got a dumb question for you, but not that all of mine aren't dumb, but when the judgment of a U.S. district judge, in this case, Aileen Cannon, is completely overturned by a federal appeals court, is there any career or reputational harm to the district judge? Like the next day in the judge's chambers or the judge's, coffee break room, are the other judges like, wow, that was lame? I mean, is there any blowback?
This case, this case is unusual because it involves a former president. So, there certainly could be the coffee chatter about it. But look, judges get overturned. I mean, that's how we have an appellate system. That's how cases end up going up to the Supreme Court. So in this particular case, it's very high profile, obviously. The original, in my judgment, and obviously in the 11th Circuit's judgment, the original judge's opinion was not based on the law and was not well reasoned, but judges get overturned. That's basically how the system
You said that in a very
is set up
nice
to
way.
work.
You said that in a very nice way. The judge's ruling was not based on the law or reason, but Carrie Cordero, Ellie Honig, David Urban, appreciate it. Thank you.